There we go. That's what we wanted to hear. All right. So I got to kind of just hey, anyway, it is October 29th, Tuesday, October 29th, and got a great session going on for you. Miss Wanda Roberts from Linnell and Associates putting on our program today, the probate for real estate professionals. So without any further ado, it's all yours, boss.
Thank you. Well, good afternoon, everybody. As Darwin said, I'm Wanda Roberts. I'm an attorney that works at Linnell and Associates. Now, you may know Linnell, we are a real estate law firm. So all things real estate. But I am not a real estate attorney. I'm a probate and estate planning attorney. So today we're going to talk about probate. I know you're all so excited. Yes, sir.
What did you say planning attorney?
Estate planning?
Yeah.
It's
You didn't say state, you said planning attorney.
so I work with probate and estate planning. So helping people draft, their wills, their
You
trusts.
get too many questions from me.
All right. So, well, now let's see if we can make this go.
Going?
No,
Well, it was going.
it was going. We had it
Go.
perfectly fine.
There you
All right. Adjust. That's all we need to do. So, probate is the legal process that we have available to make sure when somebody passes, their assets can be transferred to whomever should receive them, either as a beneficiary or, say, in the case of real property, if that particular home is going to be sold. Probate is what allows us to do that. Now, you guys will see as I go along, because this is a legal credit, there'll be references and you'll see MCL or Michigan compiled laws. So those are the sections of the statute or the law where these things come from. So EPIC, EPIC, is the Estates and Protected Individuals Code. And that's what determines what types of issues, cases, matters that probate court, the probate judges, will hear. So looking at these, as you can see, when people have passed, if they have a will, a trust, or if they don't, their estate is subject to the rules of the Estate and Protected Individuals Code. Also, if there's property here in Michigan, let's say somebody's a resident of Florida, they have a cottage here in Michigan, that property is subject to our probate courts. Also, as you may know, we've heard of people, either young children or older adults, needing a guardianship or a conservatorship. That's determined by our probate courts. And additionally, when people do draft a trust, most of the time their goal is to not have court involvement. But as I tell people, if families can't get along or we can't get along, the court will decide for us. So if there are families that are fighting over the trust, the terms, the administration, probate court will also be the place where those disputes are handled. So probate court, probating an estate, is done in the county where the person resided when they passed. So maybe, I'm living in Macomb County, but I have my son who lives in Washtenaw County. I go and live with him. I happen to pass there, but my residence is still Macomb County. It's where my driver's license or my state ID is. That's where I file my taxes from. So in Macomb County, if it's needed, my probate estate will be open. Does that make sense? All right. So, as I mentioned in the beginning, probate court grants someone We call it a personal representative, but it grants them authority to gather the decedent's assets. And as I tell personal representatives, you need to gather those assets and basically put them on either two columns or two separate sheets. What assets are probate assets and what assets are not. Then, of course, the personal representative has to pay the debts and taxes, settle those things for the deceased person, and then eventually transfer the assets again, either to the beneficiaries or, like, if a house needs to be sold, that money goes into the estate bank account and then eventually gets transferred to the beneficiaries. Now, when I talk about probate court, there's basically two things I mean. So probate court could mean you go to the county courthouse, you go up to the probate court counter, you file documents there. The people behind that counter look at everything and go, great, this looks in order. Here's your letter of authority. Or you could be filing a petition, which then goes to the judge. So if you file a petition to open probate, then the court hearing is going to be set. At the court hearing, the judge will say, yep, you're the personal representative. Yep, here are the heirs of the estate. Yep, their will is accepted, or they died intestate without a will. So there's a couple different avenues to get probate opened. The other thing to also remember is in Michigan, we do have a small estate process. So we have, as I call, the regular probate, where you file an application or a petition, or the small estate. So if someone passes away after February of this year, if their estate is valued at $50,000 or less, that's their whole probate estate, then a small estate process can be used. It's a lot quicker, a lot easier, more cost effective, but again, it has that $50,000 limit or cap. So when we're talking about probate, I have people think about if you're in a situation and you need a deceased person to sign something, probate's going to need to be opened. So if there are any assets, say in our own name, with no beneficiary listed, it's not a jointly owned asset, it's not titled to a trust, it's just in our name, probate is going to be required to move that asset. So this is where too it gets back to really having to understand which assets are probate and which assets are not.
That makes it more clear.
So for example, it usually ends up, the common thing is mom and dad had a home, mom and dad's name was on the deed. Mom and dad are now gone. The children, one of the children, like, okay, we need to either transfer ownership of mom and dad's house, to one of us, or we need to sell it. Well, if it's just in mom and dad's name and they are both gone, we need the signatures of someone who's deceased.
But you are talking about there is no trust, no will, no.
No, it's a probate asset. So that's why it's important that we look at when a person passes, okay, they had a bank account, checking savings. Did it have a beneficiary listed? Sometimes as we get older, we do add our adult children as joint owners on our bank account. I do not recommend that for a variety of reasons. There are other avenues to take care of that. But if the asset is jointly owned, it's not probate. If I have a mutual fund and I title it to my trust, again, not a probate asset. It's going to be managed by my successor trustee. So that's really one of the first jobs of a personal representative, is to determine which assets need to be or must be probated and which assets do not need to be.
One quick question. So what happened actually to my mom, her dad had passed away years ago, and they had said he had a safety deposit box at a bank. They didn't know what bank, they didn't know anything, so
Mhm.
the government got everything. How do you know, like, let's say the parent doesn't say, how do you even know where to start with it? Will they disclose that information to you? Like, hey, there was this box under, your dad's name, and here, this is, to give into his wife and kids.
So, couple things with that.
Just because they might not hear what she just said.
Okay, so the question was regarding a safe deposit box. And how do you even know it's there if your loved one didn't even tell you that it was there? And how do you find it if you know they have one, but you don't know where they have it? That is where a personal representative, once they're appointed, becomes not only an investigator, but an actual like detective of having to figure out where are people's assets. And it might come from looking at the mail. It might be on an annual statement from a bank. Sometimes even looking at their tax returns can give you an idea of where they banked, what they might have, but it's a problem. And that's part of the big job of a personal representative, is figuring out where are all my brothers or my mother's, or my grandmother's assets. Now, you really, in order to access that information, you need that letter of authority from the court. Because if you just start calling people, they'll say, well, who are you? Well, I'm the daughter. Well, do you have, an order from the court, or do you have authority? Because once a person passes away, particularly financial institutions, once they know they've passed away, they lock everything. Online access, it's all locked. And so that's why a personal representative needs to be appointed to do that detective work. Just a little aside, over this last year, I'm not a fan of safe deposit boxes. I've had 3 cases where it's been a hassle, where the bank, in one case, the personal representative, she wasn't appointed yet, but she simply wanted to close it, and they wouldn't even allow her to close it. There was nothing in there. They said you have to go to the court, and get an order or get a document that states you can close it. So when people say, well, I have the key to the safe deposit box, that's great, but that does not mean the bank is going to allow you to go in there if under their rules you don't have the proper authority. So,
So if not, the government takes it.
well, and then far as if eventually where you're, I like this word, it's kind of cute, it's called a sheets. So it's a legal word. At some point, if your assets aren't claimed, it may a sheet to the state. But what'll happen first is in Michigan, it may end up on that unclaimed property website. And so when we work with personal representatives, that's part of what we tell them is your job, finding all of the assets, understanding all of the debts of the decedent, but also checking that unclaimed property website. And I don't know, and it's on my list to actually look up of what is like the timeline of a bank has a bank account. There's no beneficiary, there's nobody that claimed it. What is the timeline for when it gets listed as unclaimed property? How long does it stay on unclaimed property? I don't know that answer, but I'm going to figure it out.
Okay.
So
I have
when, oh, does we have another
I have a
question?
Question.
No, finish what you were saying. I do have a question. So
Okay, I'm
when-
done.
Oh, okay. So in the case of prior to death, the homeowner adds their son to the deed. There's an existing mortgage on the property.
Hmm.
Would you recommend that the surviving son deeded to the property continue to make mortgage payments? Should he contact the bank and advise them that she is deceased? And if he does that, now does he face the possibility of having to be pre-approved for a mortgage, thereby facing possibly a higher interest rate, credit check, approval, denial? what would be your recommendation in a case like that?
So, very good points, and I'm gonna give you my attorney answer. It depends. So it's gonna depend on the facts of the case. In that, for example, I am now working, we opened a probate case. We have a man and a woman, we're in a long-term relationship. They never married. The house was purchased, but it was purchased under her name. The mortgage was in her name. He thought that his name was on, at least on the deed to the property. It was not. Everything was in her name. She then passed, but the two of them were living in this home, their home. Well, as you may guess, under the probate law, he has no claim to anything. They're not married, he's not related, she didn't have a will. So what he did was contact the bank because he's living in the property and he wants to keep the property. And he did contact the bank or the lender and said, hey, I want to assume this mortgage. He did qualify to assume the mortgage, which, as you may know, sometimes clients can't do that. But he's been continuing to pay the mortgage because his long-term goal is to get his name on the deed, assume the mortgage, and reside in the property. Now, it would be different if he's like, well, I'm out. Like, I don't want this house. I'm not responsible for the mortgage. In that case, then, again, a family member needs to step up, notify the lender, and then generally, you would not be making any more payments. But again, it depends on what your goal is and what's going to happen with that property. I've had clients where there's still a small mortgage, maybe less than 25,000 on a home. Their parent passed. They can't qualify to assume the mortgage. So what they're doing is they're residing in the home and they're paying the mortgage. They'll deal with the title to the property and they'll deal with the ownership once that mortgage is paid off. So that's why I say it depends. Did
Can I
that
ask
answer?
another?
Sure.
Yeah, kind of. Well, most mortgages now are not assumable. So would this assumption be granted to him if he could in fact afford it? Or would the contract with the lender that says that this is not an assumable mortgage stand?
So the contract always dictates the day. Whatever contract has been signed and whatever terms of the contract are there will determine what happens. So what I was describing, there isn't anything in probate law that would usurp a contract made by a lender. So it might be if, in this case, the first case I explained, he is able to assume it, they're going to allow him to assume it. If it was not available, then he may have to qualify to get it on his own. Again, like you said, different interest rate. So it really depends on what's happening and what the family, what the client want to do with that property.
So here's a question, and Cheryl, you might have to clarify. She's got, does my mom's Bluebird deed cover me on her home?
So I'm going to answer that question after I tell you guys about the forms of real property ownership in Michigan. So as you can see on the slide, in Michigan, we have 4 different types of tenancy or the way that we own real property. We start with tenants in common. So tenants in common is the default type of ownership if there is more than one person on a deed and none of those people are married. So say if myself and Darwin buy a piece of property, it says Wanda and Darwin, doesn't say anything else, lists our address, lists the property, legal description, it's notarized, great. Darwin and I own that property as tenants in common. He owns half, I own half. Now, in the deed, if it says Wanda owns 60% and Darwin owns 40%, then that's what we would own. But we own it as tenants in common, which means I have a separate interest that I can put into my estate plan. I can sell it. He can do the same.
Okay, let's go back to the question she asked me.
With the Ladybird deed,
Yeah, and you were saying that if he legalized suing a mortgage or something, it is the one to do nothing. One of the family has to apply or
Yes.
but who's a member of the family who can do that? And who's gonna sell the property in that case? Who's gonna give the property?
so
That's probably.
I will also get to that question a little farther down in our slides when we talk about who can be a personal representative and what exactly their job is. And then in terms of who's going to receive our assets, just know if we don't make a will or a trust, the state of Michigan has made one for us. And it will go the way the Michigan law says your assets are going to go. The next type of property ownership is joint tenants. This one is a little bit tricky in that these two words, joint tenants, are very powerful. So if Darwin and I bought a piece of property, it says Wanda and Darwin, joint tenants, with all the other stuff on the deed. If Darwin passes, his interest comes to me. Or if I pass, my interest goes to him. There is a survivorship right with joint tenants, those two words. But wait, if I, for some reason, I'm just kind of tired of dealing with Darwin and I don't want to own that with him anymore, I can actually sell my share and sever our joint tenancy. So let's say Terry is the new buyer. She buys my ownership piece. Now Terry and Darwin are tenants in common. So joint tenants has benefits for survivorship right as well as the option to get out of ownership of that property. Okay.
There is, if they have, okay, does he has the right to ask them for his approval?
No, not in joint tenants. Nope. If I just decide I don't want to own this anymore, I can sell it to you. Don't have to ask Darwin. So again, being very clear and understanding the types of terms you put in a deed and what they mean.
So you are
It's important.
talking about the deed,
This is a
not
deed.
the trust, not the will.
No, these are forms of property ownership that are evidenced by a deed.
And you just sell the equity, and you split the equity. If you're wanting to sever the tie, right? If you have joint tenancy and one person wants out, then they just want to buy themselves out and sever the tie, they go away with money. And does it depend on how much they've paid into it or through that period of time they've been there? Or is it just like a 50-50 split?
It's like a 50-50 split depending on what the current value of the property is at the time that one of them severs that ownership.
So you need an appraisal, right? You would need an appraisal.
Well, I would definitely want one. I'm sure Darwin would want one. Because I, of course, want to get the most of, the value, what I'm getting out of it. And of course, he wants to make sure, what his value is of the property as well.
Right. Okay.
So they are not agreed for the appraisal, they have to go back to the courts.
Sorry, ask me that
If
again.
they are not agreed for the appraisal, to do the appraisal. If one party is not agreed,
Like if,
we don't wanna do appraisal.
like Sam and I had a big fight and I don't even want to deal with him. Can he get away without even working with me or?
Yes, he could try it. He could go get his own appraisal.
There is no agreement, final agreement. what we can do, we have to go back to the court.
Yes. So again, if you're not liking what's happening with the transaction or with a contract or with a relationship, you might have to go to the court and say, look, you need to make a decision.
And the court will decide how to do the appraisal, or the appraisal, my opinion is appraisal has to be done. Either by agreement or through the court.
Well, you can always get an appraisal. You don't have to ask anybody. I mean, if you're gonna try to make Darwin pay for part of the appraisal, then that's a different issue. But I can go get an appraisal. He can go get an appraisal. So the next type of property ownership is the joint tenants with rights of survivorship. So I'm sure you've seen it, joint tenants with full rights of survivorship. You've seen JTROS. This type of ownership, I call it the last person standing wins. So this type of ownership, if it lists Wanda, Darwin, and Terry, and one of us passes, our interest goes to the other two. So the last person alive in this scenario is 100% owner of the property. In this case, I don't own a separate interest, neither does Darwin, neither does Terry. We own it all together. Now, if I don't want to own it with them anymore, and they don't want to buy me out, and they don't want to sell it, this is where, again, I may have to go to the court and file an action for partition. The court will then force the sale or force a solution of someone buying someone out. But this joint tenants with rights of survivorship, again, works if it's what you want to be working in that deed. For example, I had a client who owned a home with his mother, father, and him, adult son. They were all three on the deed, and it said joint tenants with full rights of survivorship. That's how they owned it. So then dad passed. No problem, right? Mom and son now own the property. But wait, for some reason, mom and son thought or decided to have another deed drafted. Why, I don't know. The new deed that was drafted says mom and son, that's it. That deed gets recorded. Then, of course, as you can imagine, mom passes. Uh-oh is right. So now son owns half of this property because that new deed that was executed listed mom and son, nothing else. Default is tenants in common. So now mom's estate owns half and son owned half. So son has to open probate to get letters of authority to sign off mom's interest. If they would have just left it alone, they didn't have to do a new deed, and he certainly shouldn't have had to pay to probate. So again, I get on my soapbox about when you're executing a deed, be really clear about what type of ownership it is, who has that ownership, and you understand what's going to happen when people may pass. The last type of ownership is for married people. So any couple that's married and they buy a piece of property. So if my husband, Bruce, and I buy a piece of property, it doesn't say anything after our names. It just says Wanda and Bruce. We are married, so we own that as tenancy by the entirety. Keep in mind, there isn't any magic that happens. If Bruce and I are going to get married and we buy a home and we have our names on the deed, Wanda and Bruce, but we're not married yet, doesn't say anything else, we're tenants in common. But then we get married. Doesn't change our ownership in the deed. If we want to own it as tenancy by the entirety, we have to execute a new deed. So part of that is I like that because we, me, you, the world, we need to know who the owner of that property is on the four corners of that document. And there's not something else out in the world that's going to change it. Our property ownership is evidenced by what it says in the deed.
So are you saying that engaged couples should put tenancy by the entirety after their name?
They can't unless they're married.
Oh,
It's only if you're married. Now, if you're not married, but you're intending to get married, you may want to add the joint tenants with rights of survivorship. You may want to add joint tenants, again, if that's your goal. Maybe it isn't their goal. Maybe they want it to be separate in that they're not married. So the gentleman, you know, his share can go to his family and her share can go to her family. But that's why it's important to understand the type of tenancy when you execute a deed. Go
I
ahead.
think I really got to throw this in.
Oh.
Because we're all getting really great information. But remember, we're not attorneys. So the whole point of getting all of this information
Yeah.
is to go, you need to consult an attorney. We should not be giving legal advice. What we should do is to learn enough to know that we need to refer them to the attorneys such as Linnell and Associates, and they'll place it with the right person. That
Absolutely fair. Yeah,
it's
nobody,
important to be able to bring that right now.
very good. Nobody wants to get caught practicing law without a license.
So cause I sell to a lot of engaged couples and within a month or so, like they're married anyway. Should I tell them, hey, do tenants with full right of survivorship, tenants that come with full rights of survivorship, leave them alone, however the title company does them? Or tell them to get a quick claim deed drafted at closing, then they can just sign that anytime.
It's in question. We have couple now, they have fiance. they
Yeah.
gotta Get married, when we don't know. Mortgage is in process.
Yep.
So the deed is gonna be, the title is gonna be in both names. Let's say they're gonna get married in a few months, then they should do it.
So
I
again,
mean,
I would say it depends. You know, if I'm talking to the couple, I would be explaining these types of tenancies as an attorney. So they understand, maybe they want it to be tenants in common and they each own a separate half until they're married. Maybe they want the other one to get it upon one's passing.
But the title is.
There's nothing you can do until they're married. When they're purchasing the property, they are an unmarried couple.
Yes.
Their names will go on the deed. Now, what type of tenancy, they're gonna have to decide that. If they later get married, they have to execute another deed.
Oh, they have-
If they want it to be tenancy by the entirety as a married couple.
Is there advantage of tenancy by the entireties versus tenancy in common with full rights of survivorship?
Look at him, just queuing me right up. As you can see on this slide, there is the benefit of creditor protection if we own the property as a married couple. So let's say my husband develops a terrible gambling habit and the creditors are knocking on our door. Both of our names are on the deed to the home. We were married when we did it. We own it tenancy by the entirety. That creditor cannot come and scoop that home out from under me because we own that under tenancy by the entirety. The other forms of property ownership do not offer that type of protection.
So if his husband, he owned the house, he just married, married her, is she give automatic ownership of it, or we have to add her name to the house?
If her name is not on the deed, she does not own that property.
That's
So
down
if
to the
something
owner.
happened to me, she never be able to get that owned the house?
It depends. Again, I will say, if you have a will or if you have a trust, if it says my wife gets all my stuff when I pass, then your wife will get it. But as I said, Michigan has a will for you if you don't do your own. In the way our property goes, if we do not have a will or a trust directing it, it first goes to the surviving spouse, but the spouse does not get everything. The surviving spouse, like if my husband passed, he didn't have a will, I'm entitled to the first 100,000 and half of the value of the estate. There's a formula and it depends on what our situation is with children. If we have children that he has and I have, do we have children together? There's a whole statute that says spouse gets first, but the most a spouse is gonna get is 75% and half of the estate. So no, if like the husband's name is on the deed to the home and the wife's isn't, the wife does not automatically get that home.
So you recommend it,
You need
Uh,
to put it,
even the house is paid off, I'm saying, no mortgage.
yep, doesn't matter. And even if there is a mortgage, the deed is going to evidence who owns that property. And even if it says husband, a married man, again, there's no magic that adds the wife's name to it. You have to physically add the names to the deed.
So the husband passed, but the house is still in his name, the wife is then included, who's gonna take the house?
It has to be probated.
Okay.
And then the estate will be administered under the probate law if you don't have a will
Who gonna
or a
get the
trust.
whole share? How about his children?
She will not get the whole share if you don't have a will.
Children they'll be taken to?
So under the law, if you do not have a will, it goes to spouse with the formula, then children, then parents, then siblings, then grandparents. So if you don't want your assets to go that way, you need to at least have a will.
Same thing with the bank.
Or, yes, or
Even
yeah.
if they want to have some money in the bank, they have nobody.
every asset. You have to either have a jointly owned
But you
asset.
say that after the death, it goes to the belongs to do it to somebody?
It will go to someone, but it will go according to the statute in Michigan if you don't have a will.
Even if you tell the banks, this is what I want, beneficiary.
If you put a beneficiary on it, it is not a probate asset. So
So
we're
they
back
could
to
get
the, yeah. So,
Even the wife too.
yes, you either have to put a beneficiary on an asset or a jointly owned asset or title it to a trust. Otherwise, it will be probated. And if you don't have a will, the state of Michigan tells you it's going to go to your spouse by formula, your children, your parents, your siblings, your grandparents.
Or they own that.
If you don't like that, make your own will or trust.
Mhm.
Couple of questions, sir.
I
Okay.
have
Go
a
ahead.
question. Two questions.
Brenda
Okay.
will come to you.
One is for the will, if one of the spouse give the access to the beneficiary, to the wife or to the husband, and they have children, do they have to put their children's name information in the will? Or not automatically is it gonna go to the children after the beneficiary dies?
If you want your assets to go to your spouse, then your children, you have to put that in the will. There's nothing that automatically happens to change the document you've drafted.
That has to be for like, from the spouse to, okay.
Yeah,
Then to the wife, and the wife, she is the first beneficiary. Then from the wife to from the beneficiary after that, after that, to the kids.
So what I'm gonna say is we're gonna have to talk about that at a different time because that's regarding estate planning. And right now, I want to make sure you guys get the information regarding probate. Okay,
The other question was about the deed.
write it down, write it down. And we had another one online.
Yeah, so Brenda's out there. Go ahead, Brenda.
Thanks, Darwin. I don't know if it's a question or a statement, but situation. Owner of a property quit claims deed to his sister, who was the original owner. Apparently, she quit claimed the deed to him at some point. The brother dies. The sister then puts the house on the market and sells it. Title company has done their search. 2 days after the sale, supposedly a daughter of the deceased comes forth and says that she and her brother have an equal share in the property. That's gonna go back to the type of deed or who was named on the quitclaim deed and the type of tendency they had, is that right?
So I'm
Which-
gonna say yes.
Which would
So the bottom line-
determine if the supposedly existing children would then go back to the tenant.
So I'd
And
start
if
with
they had
what,
a claim, it would go to them depending on how that quit claim deed was written, what type of tendency. So
okay,
if it
so
was,
one,
uh-huh,
yeah, that is too much information for me to keep track of and answer because I'm not able to give legal advice at the moment. But what I'll say is, one, it's exactly right what you said is you need a title company to do a title search. And that title search will tell you who's in title, what clouds are on title, so that when that home is sold, the new buyer can get clear title, as you guys know.
right, well, that was my thought, and they didn't find anything. So apparently this so-called probate was not filed for until after the sale, because had it been before, the title company checks the title again just the day before the closing. So if there was something out there, they would have found it. So my thought is they probably didn't file probate or may not have even on that date. It's something they were thinking about doing or may have been in the process of doing, but that probate process hadn't been completed as of the day of the sale.
Yeah, I mean, there's a couple things happening with what you're talking about. So you're talking about the probate process, but you're also talking about people executing deeds. And yes, it can make this very messy. So I'm going to get on my other soapbox. Quit claim deeds have a place, a very limited place. But families, what I've seen more and more, if you're just going to keep quit claim deeding property, it creates huge issues for your family that's left. So again, I'll caution people, when you're executing a deed, you need to talk to the right person, be it a real estate attorney, to understand what you're doing. So like in our firm, if somebody calls and says, I need a ladybird deed or I need a quit claim deed, they actually come to me and I have a consult with them because I want to know, what are you doing? What's your intention? What are you trying to accomplish? So we can properly advise people. But that doesn't necessarily mean that, as you were saying, Brenda, that a family member or someone else could come in after the fact and try to upset the apple cart. Maybe they have a case, maybe they don't. So, property ownership, it's really important that you guys know what it is, as Brenda was describing, but know what it is because you need to know who needs to be at closing to properly transfer title of this real, this home, whatever, it could be a vacant lot. For example, I had a case where husband and wife were residing in a marital home. It was their second marriage. They had no children together, but they both had adult children. The husband's name was the only name on the deed to that home. Husband, one of his adult daughters, decides to talk in dad's ear and got him to execute a new deed listing dad and daughter owning that marital home. They're tenants in common, dad and daughter. As you can guess or predict, dad passes. So now we have wife living in this home that is now titled half dad's estate and half to his adult daughter. There was more things that happened in court. There was a lot of fighting. Daughter even tried to put forth a false will to the court saying dad completely, didn't want to give anything to his wife, which was not true. That was eventually withdrawn, but after a lot of court hearings, with the wife being appointed as the personal representative, because if there's no will, spouse is the first one in line. Eventually the house was sold, but wife as the personal representative and daughter as the half owner all had to sign at closing. Yeah.
I got the question now.
Mhm.
Okay, about the quitclaim deed or trust or will. Usually when you draft one of them, has to be recorded.
So again, if you're drafting a deed, I strongly recommend that it get recorded. Keeping deeds in a drawer is not going to be helpful to you or your family. We are in the world where our title companies can do that search. And if it was me, man, I want my ownership recorded.
Okay, so if you draft a deed today, and it's not recorded, and a month later, the person died.
Yep.
Who's in the deed?
What happens? A deed is effective upon execution. So the deed is still good. A deed has to be notarized, yes.
Not notarized, maybe not.
Again, that
Could be.
would be a question for the court if there's a fight over it, but a properly executed deed has the grantor's name, the address, the legal description, you know.
What about the trust and the will? Has to be recorded too?
So if you're doing a trust, as I mentioned, you're doing that because you don't want to have court involvement. So I do not encourage my clients to ever record a trust. You can if you want. You also do not have to record a will. I do encourage clients, if you have a will, take that original to the probate court in the county that you live and tell your family where you put it. So then the original is going to be in that probate court vault. So,
So just the will, not the trust. You take it to the county.
yeah, and I'm going to try to move on from answering questions about estate planning so we can get through the information about probate.
Would you say Macomb County and Oakland County are both 30 days probate?
No,
Okay, what would you? say
Never.
the estimated time?
So
Never.
I was gonna say,
So
that
we'll
was
get
one
to
of the
that.
questions
Yeah, we'll get to
come
that.
up. All right.
Yeah, we'll get to that.
We'll get the timing.
Yeah, that's absolutely not. So who can serve as a personal representative? This is the priority under the law. It starts with your will. If you have a will and you said A and B and C can be my personal representative in that order, 99% of the time, the court's going to say, great, this is what you wanted. This is what we're going to do. Unless for some reason the person or people you nominated are completely unfit or unable, they're going to follow your wishes. Now, if you nominate a person in your will and they're not available, the next person in line is your surviving spouse. Let's say you nominated your adult child rather than your spouse. Let's say they're not able to do it. The spouse would be next in line, but they have to be a devotee. A devotee means they're mentioned in your will to get something. If you don't have a surviving spouse and whoever you nominated isn't available, the next people in line are anybody else that you gave something to in your will. So they're a devotee in your will. If you do not have a will, as I mentioned earlier, your surviving spouse is the first in line of priority to serve as personal rep. If you don't have a surviving spouse, then the court looks to your other heirs. These are blood relatives or legally adopted family members. So it has to be someone that's in your bloodline, be it your parents, your siblings, and your children, your grandchildren, but it's got to be in your bloodline. As you can see, a creditor can actually open a probate matter or request a personal representative be appointed to open a probate matter. There is a time constraint on that. But if someone, the decedent, owed me money and I need to get probate open to get paid, I do have a path to that as a creditor. The last option is if there are no family members, nobody wants to, or there's nobody available, there's nobody living. Michigan has a system where we have a public administrator. That is a short list of attorneys. They are appointed by the Attorney General of Michigan. And so each county, luckily in Macomb, Oakland, and Wayne, we have more options. Some counties across Michigan have one attorney listed. So you got one option to have a public administrator open and probate that estate. So I talked about this letter of authority, and this is really key for all of you. If you're going to work with a client who says, oh, I want to sell mom's home, or we got to sell, dad's cottage, and mom and dad or mom and dad have passed, you must deal with the person named on that letter of authority. No one else has the authorization to act on behalf of that estate. So if somebody is coming to you and you're like, great, we can list mom's home, you say, show me the letter of authority before you sign any kind of documents. The letters of authority will be restricted or unrestricted. So you need to look clearly on that letter. It's one page, it's a court form, to determine if there are restrictions or not. So this is a letter of authority. This is what you need to have a copy of before you start working with a client to sell any real property. The person that's blacked out up there in the upper left corner, that's the name of the person you're going to work with. This will tell you the file number in the upper right corner, that case that was filed with the court. It'll tell you the estate of, and you see there's a little blue X. That is where restrictions would be listed. On this, there are none. The other key you want to look for is right under that X. It says these letters expire. You do not want to get to the closing table with an expired letter of authority. The title company will not close. Also, on the lower right corner in this, you can see a seal. It's an electronic seal. This is from Wayne County. It's the only county that I'm aware of currently that electronically seals their documents. It comes in the email. Macomb, Oakland, Washtenaw, Genesee, Lapeer, every other county I'm dealing with, they still have that raised seal crimped letter. So you're going to have the actual original with that crimp on it with the raised seal. This is a letter of authority that has restrictions. So where my blue squiggle is, you'll see here there are two restrictions. One is that the fiduciary, which is the personal representative, cannot enter into a wrongful death suit on behalf of the decedent without the court approving. The other one is real property cannot be sold without approval of the court. You really, really need to know if the person you're dealing with is the actual authorized personal rep and if this is restricted. Because if there is restrictions to selling the property, that means there's going to have to be a petition filed with the court. It's a petition for the sale of real property. There's going to be a court date. The judge is going to have to prove it. Then there's going to have to be a certified order gotten. So then at closing, you're going to have your valid, not expired letters of authority and a certified order for the sale of real property. Then the title company will allow the closing. The one thing I want to warn you guys about is even if the letter of authority that the personal representative has is unrestricted, like this one, does not mean there's not going to be a petition for the sale of real property. That's what I will advise the client regarding. So even though the letters of authority are unrestricted, if we've got any fighting with any of the family, and I see this all the time, one sibling says the house should sell for more. The other sibling says, I don't care, I want to get rid of it. If there is any fighting, I need to protect my client, who is the personal rep. I may advise them, I think you need to file a petition. Then it gets filed, the court approves it, I protect my client, the court has ruled, the property gets sold. I just want to warn you guys, I'm not trying to thwart your business, but I do need to protect my client, who is the personal representative. This is a general summary of a personal representative's responsibilities. So when they're dealing with you to sell the home, they've got a whole pile of other things that they have to do. So we talked about gathering the assets, gathering the debts. They have to file that probate inventory. And again, that's only the assets that need to be probated. That's not an asset with the beneficiary. That's not an asset titled to a trust. That's not an asset that's jointly owned. If a person passes away, and I'm going to file probate tomorrow, and that person has been deceased less than 3 years, I also am required by the law to publish what they call a notice to creditors. In that case, there's going to be a 4-month waiting period. From the date that notice is published, the personal rep has to wait 4 months to see if any creditors properly file a claim. Now, keep in mind, that does not mean that the house cannot be sold in that time. As soon as the letter of authority is issued, that personal rep can go about their business administering the estate. But just know that the personal representative has a whole bunch of work to do even after that house is sold. They have to prepare an accounting, what came into the estate and what went out. They also have to settle debts and taxes. There is an order under the law. This is the order of priority of who gets paid from a probate estate. Costs and expenses to administer that estate come first. So that's court fees, that's attorney fees, that's keeping the lights on in the home till it's sold, making sure the heat is on, getting a dumpster to clean the house out. There's all kinds of expenses in administration. So if a family member pays for that out of their pocket, they're going to get paid back first. Then reasonable funeral and burial expenses get reimbursed to whomever paid that. Homestead, family, and exempt property, those go to either a surviving spouse or minor children. Then there's the federal taxes that have to be settled, last medical expenses, state taxes, and all other claims. So when people say, well, should I pay my mom's credit card? No, because maybe there'll be money to pay it, maybe there won't. But this is the order in which debts must be paid. And if a personal representative, say, pays a credit card and didn't pay somebody back for funeral expenses, the judge will be very unhappy. Because I've had that happen in a case. And all of these things have to happen before any assets gets distributed to anybody. So if you guys are dealing with family members that say, oh, there's, we're closing on the sale of the home, when am I going to get my check? You're going to get your check when probate's been fully administered. Nobody's getting a check at closing. The net proceeds of that closing will go into an estate bank account so the personal representative can finish their job.
Usually, what's the time frame for that?
So, meaning from
Date of closing.
minimum, all right. So a probate estate generally is open a minimum of 5 months. So again, it depends on where the personal representative decides to sell the home. Some families get on it right away and they want to get the home sold because that's the biggest asset, so they can get money into the probate estate so they can pay for other expenses. Some families just can't do it. They can't get the family into the, into the state. They live everywhere. They don't want to go through mom's things. Maybe that's the very last thing they do. So it really depends on that personal representative in the family.
In
When,
Michigan, there's a time.
pardon?
In Michigan, there's a time to apply for the probate.
No, you can apply for probate anytime after a person passes, after you have the death certificate. I've had people literally call me on the day that their parent,
That must be years.
could be years. I've got one that was opened, gosh, I think she died in 2015.
Huh?
Her name was still on the house. Family lived in it, but now they want to sell it. So we got the house sold. and now we're finishing it, but yeah, I mean, depends if there's assets hanging out there in that deceased person's name. Then, if probate's going to take longer than a year, which in many cases it does because these federal and state taxes have to be filed, then the personal representative would have to file a notice of continuing administration with the court. They would get updated letters of authority, because a lot of times they're waiting for these final taxes to be filed, prepared and filed.
Um, if the person died and there is nothing like no quitclaim deed, no name after the person who died. And they gotta go to the probate, but if the house is vacant, or is it a process of probate? What about the insurance? If they have no insurance in the house?
So it's the responsibility of the personal representative, once they're appointed, to protect the assets of that decedent. If nobody's doing it, then nobody's doing it.
So if nobody's doing it, if something happened to the house.
Then it burns down. Then it burns down. Yeah, I mean, if no family member's stepping up and, no, exactly. So then you might have a lot that you need to sell because the house is no longer there. So if a person leaves a will, probate is not necessary. True or false?
Oh, no, probate's necessary. That's a great question.
Yeah, and that's one of those, in general, if a person leaves a will, probate is not necessary. No, it's a tricky question, kind of, but the will is what you leave to tell the world who and how you want your assets to go. Probate, again, is there to make sure that title to those assets can be properly transferred. So if you have a will, that does not mean you're going to avoid probate. It depends on how your house is titled, depends on how your bank account is titled. It depends on how your assets are titled. So in a case with a home, mom and dad are on the deed, nobody else, mom and dad are gone. Mom and dad's will says, our kids are going to get it. That's great. The kids will get the house, but somebody has to open probate to be able to transfer title of that home to those children. So the other thing is a person that's named in a will as the personal representative, they have that authority to administer an estate. And again, it's another one of those questions of not exactly. If somebody comes to you and says, hey, look, here's my mom's will. I'm nominated as the personal representative. I want to sell her house. Your answer is going to be, congratulations, but give me the letter of authority. The will does not grant authority. The will is a nomination, a suggestion. The court, either behind the counter or through the judge, is the only way letters of authority will be granted.
So you might avoid probate, but you're not gonna avoid court. Right? I mean, there's gonna be somebody involved that says officially you get to be the
Personal representative. Yep, it either has to be appointed by the people behind the counter or appointed by the judge, because that letter of authority is a court document that's authorized by the court. Mhm.
If you have a will or trust, can you give a quitclaim deed?
Anybody can make a quitclaim deed.
No, sorry, my question. If I have one of them, can I, in addition to that, can I give a quitclaim deed too?
So
If it's not revoked?
again, that's more of an estate planning question. But with that, what I want to make sure to answer is the ladybird deed question. In Michigan and 4 other states, we can execute a ladybird deed. Legally, what it's called is an enhanced life estate deed. So within that deed, we can do a tiny bit of estate planning. So I can take my property and deed it to myself for my life, and I have complete control over it. I can sell it, I can knock it down, I can add on to it. But if I pass and I own that property upon my passing, my son is listed as the beneficiary in that deed. He automatically owns the property. So it is a piece. You can use a ladybird deed as a piece of a basic estate plan. You can also use a ladybird deed, which I'm seeing more attorneys do, which I also am doing, is couples, say, deeding the property to themselves for their life, and then they list their trust as the beneficiary. Because that way they keep control of their property, they can sell it, they have no problem. But when they pass, then it goes according to the terms of their
So
trust.
if my son is in the deed, I'm not gonna pass away, he's gonna own the property automatically.
If it's a true
But-
ladybird deed,
But, okay, anybody, if there is a credit, the creditors can't come after him.
he will own the property, and if you, and- correct, and you, when you own an asset, when you get an asset either through ladybird deed or when you get an asset through the gift from a will or a trust, you take that subject to the loan that's on it. Unless, again, it's talked about in the document. Like if I create a will that says my son's gonna get the home, but I want my estate to pay off any debts first so he can get it free and clear, that has to be in my document. Really, I mean, when you think about all of it, it's a contract. The will, the trust, purchase agreements, all of that are terms that tell us how we're supposed to behave and who gets to do what. So in the big picture, work with your title company. Talk to your title company. In fact, for example, we were retained to probate an estate. There were 7 children. 2 are living. 5 have passed. The family that's living thought the one sister was entitled to the property. No, all 7 are. So I have now had to inform the client, it's not going to work for the one sister. We literally have to open 5 probate cases to sign off all of their 1/7 interest.
So their kids wouldn't get it, out of those 7 people.
And there's no will, so it's going to go down. Each gets like 1/7, and then it's gonna go down to family. But I don't really know what the client's gonna do. That is like a huge problem. Again, this is why don't put your 5 kids like on this deed. I mean, there are other ways to make sure your family gets your property. I really don't know how this family is gonna do it.
So in this case, if you're gonna open 5, 6 cases, public cases, each one has to have a representative.
Correct. If they're all separate, everybody's interest is separate. So again, cautioning people of putting a bunch of names on a deed, quit claiming property to people. Again, I'm not sure what the client's going to do. So for us, we charge $2,000 retainer fee to get started working on one probate case. It's $175 generally is the filing fee to open. The publication fee is $114.40 if a person died less than 3 years ago. Then you have your letters of authority, which are $12 each. Generally, it takes about $5,000 to probate a case with no problems, with everybody agreeing. I've had them where they've been $8,000. I've seen a $17,000 bill. Depends if the family's fighting. It depends if things are contested. So it's an expensive endeavor. And there are ways to do proper estate planning to make sure you do the best you can to set it up right for your family.
So when you say $2,000, then you're gonna start from like the application up to.
Yep, everything. So we start from the application, through the inventory, through the accounting, eventually to close the estate and everything in between. So in general, keep in mind for you guys, if you run into a person who wants your help in selling a home where the sale is restricted on the letter of authority, it could be an additional anywhere between 4 and 8 weeks before the closing can happen. Right now, I'm seeing the court scheduling out 6 weeks. It usually happens toward the end of the year. It's going to be longer. Generally, it's going to be at least 4 weeks. If we can short circuit the process and all the family members agree, we might be able to get documents signed and get the judge to approve the sale without a hearing, but it all depends on the judge. Depends on their mood. Depends on what they generally do. The other thing I want you guys to know is, particularly in Wayne County, if you're dealing with property there, and a petition for the sale of real property has to be filed. Many times, the probate judges in Wayne County are appointing what they call a GAL. It's a guardian ad litem. Nothing I can do about it, nothing the client can do about it. What that means is the judge wants their opinion. Should I approve the sale or not? So this GAL is going to be talking to the attorney, maybe talking to the realtor, maybe driving past the house. At the hearing, this GAL will tell the judge, yeah, I mean, this is appropriate price. I think you should approve it. Or I've seen them say, no, I mean, this investor wants to buy this property. This should be sold higher. And the judge doesn't approve the sale. So again, there's a lot of things that happen that are beyond your control and beyond mine that might happen in this process. So with us, I try to make sure that the realtor and the title company and the client and I are all on the same page as we're trying to get this house sold. And I'm happy to loop you guys in, but I need permission from my client to do that. So that's a lot for today.
I have questions.
I have a question.
You have more
Let me-
questions?
Yeah, I
We'll
got
do
a
that.
bunch of them that are
We'll-
online here that
Yeah,
we
my
haven't
question is
addressed for a
gonna be
while.
a hard question, that's why, go ahead.
We might have to do that one after then. So, here's I think a quick question. Survivorship, 2 people on deed, one dies, it goes to the other, but she dies. Does it go to her children?
It goes to her estate, whatever that may be. And that's another interesting thing is I have a case where husband died, 3 years later, wife died. Now a family member's coming to us. Well, because wife was alive when husband died, his estate pours to her estate. Then her estate gets distributed. So it depends on who was alive
Makes
last.
sense. So then here's the next one. How much time does it take to get the personal representative appointed? And you address cost.
Well, that again depends on how fast they move, how fast the law firm moves, and if it's an application, you know, I mean, we could do it in a matter of days or a week. Or if we don't get the information, if we don't have the death certificate,
There's a lot of variables.
there's information that has to be gathered, but I mean, literally, it could be a week.
So does a beneficiary of an asset trump the direction of a will?
Yes. That's an easy one.
That's an easy one. And let's see.
That is unless somebody fights over it
Yep.
and tests it, but
Clarification, getting the approval from probate for sale is based on an accepted purchase contract?
well, it's based on the appropriate market value of the home. Some of the questions that have to be put on the record that the judge will ask is, you know, are you the duly appointed personal representative? Yes. Was this an arm's length transaction? Yes. Was it posted or advertised on the open market? Yes. So there are things that the judge goes through that they want to hear to know that this is not like an inside job or self-dealing.
We'll have appraisal too. We did that.
Yep, because when we submit the petition for sale, we'll submit the purchase agreement, we'll submit the comps. I mean, we'll submit documents to show the court this is a legit deal.
Okay, she needs to come back. Do you want,
Oh,
do you want to let them know what, you've got coming up? In
Oh.
regards to the estate planning that we will.
Sure.
discuss?
So there's a couple things just to kind of wrap this up. You guys will see our estates email. Everybody is welcome to email us questions. Myself and the two assistants, Tyler and Amanda, that I work with, monitor that email. And it's my joke is, I'm happy to help answer your questions, but if it's going to be too much, I'm going to send you a bill. Haha. But come January, we're going to be offering not only this probate for the real estate professional, which is a legal Con Ed credit, we also are going to be offering estate planning for the real estate professional. So it'll be some personal stuff, but it'll get into how you deal with property, if it's titled to a trust, certificates of trust that are needed, that type of thing. And that will be a legal credit.
And we will try to get you in here January.
Sure.
So we'll try to get her back in here for January on that one. So outside of that, guys, I think we can say thank you.
No, we are not done.
Well, I know she's gonna be here, but I want to give everybody else that time. So, guys, hope you all had a good one. I'm gonna let her escape.
Thank you, Wanda.
We'll see you again next week. Thanks, guys.
Do we have this presentation? Can we
Do
download
you
it?
have it today?
As always.
Thank
I gave it to you.
Yeah.
That was good.
And if anybody wants to hear this again, by the way, it will be recorded and uploaded to the HRC Agent Development channel. So those, every Tuesday, those go up there and you'll have that. So guys, go out, sell a lot of real estate. We'll see you next Tuesday and another one for Ignite. See you then, guys. Bye-bye.